So if you would like to introduce yourselves, that would be helpful.
So I'm Helen Vernon, I'm Chief Executive of NHS Resolution. We handle indemnity schemes for the NHS in England, and we also have a role in learning from claims to share that experience with the NHS for the purposes of safety improvement.
Right, thanks very much.
Hello, I'm John Mead. I'm Technical Claims Director at NHS Resolution.
Right, thank you very much. So just thinking about NHS Resolution, which I think has been going through some considerable reforms as an organisation in the last few years. What are the key reforms, do you think, for the journey that you've been through, and what objectives have been met?
Sure.
Would you like to say a bit about that?
Of course. So a primary aim for us has been increasing our role in the period prior to a claim coming to us. That's involved a number of work streams. One has been what we call an early notification scheme for obstetric brain injury. So for the last 2 years we've been asking for incidents which fulfil certain clinical criteria which are likely to result in a child unfortunately having a brain injury following complications at birth. We've asked our NHS Trust members to report those incidents to us within 30 days of the incident, rather than us waiting for the claim to come through what can be 5 to 6 years after the event. The purpose of that is to enable us to share learning with the organisation directly, more rapidly, and then more widely with the NHS and our maternity trust members. But secondly, also to try to reach an early conclusion on legal liability and get any interim payments of compensation which might be merited at that point to the family as soon as possible. So meeting needs when they occur rather than several years down the line. So that's been one work stream. The other has been refining our approach to how we learn from claims which are brought against the NHS in England. And we've done that by increasing the level of transparency of data to NHS trusts. We share it with them by way of scorecard information, but we've also been undertaking some deep dives into particularly prominent areas of claims, be that because they have high volume, so we've got lots of claims coming through in relation to the same sort of thing, or where they are of high value, so they are particularly significant in terms of cost to the NHS. We've focused that on some main big areas over the last 3 years. So we did a report on examining 5 years of cerebral palsy claims where liability had been admitted. Then following that we did a report on mental health suicide. And in the coming year we have a focus on emergency care claims, which are the highest volume specialty we receive. And the way we do this is by recruiting clinical fellows to come and work alongside our claims teams for a period of a year. For 6 months of that they spend their time looking in detail at the claims, and then for 6 months engaging with the wider system partners such as the Royal Colleges to get buy-in and traction on recommendations from their findings. And then we've done some smaller deep dives on specific areas like needle stick injuries, Cordon-Requiner syndrome, pressure ulcers, those sorts of things which are common features of claims experience. So that's been two things. One is the getting upstream in relation to maternity incidents, but secondly, refining our approach on learning. That's very much a move away from our previous approach, which was one of inspection against risk management standards, and we discontinued that some years ago, primarily because there was some overlap emerging with what the CQC were doing, but also because there was little evidence of either a correlation between the outcome of the risk management inspections and claims experience, but also trusts were not progressing through the risk management levels in the way that we had hoped. And then I suppose the third thing to mention is that we've been making our pricing for the indemnity schemes more sensitive to claims experience, and trying to also use the pricing to incentivise best practice in relation to safety improvement. And we started that with maternity by incentivising 10 actions in relation to maternity safety, which had the agreement of all of our arms and body colleagues and the Royal Colleges, and using that as a way in which Health Hospital Trust could get a discount on their premium for fulfilling certain criteria. So those, I think, are the main areas where we've been focusing on in the last few years.
Helen, how are you measuring the impact of your new patient safety role?
I think that's very difficult and challenging. We're trying to evaluate the impact of initiatives like the Maternity Incentive Scheme, but in doing that, we would have to untangle the impact of what we're doing from the patient safety efforts which are taking place across the system. And that's quite hard, because it's almost trying to prove a negative that by what we have done in relation to learning or incentivisation, we have prevented an incident happening which would have occurred were it not for our...
And the way, as you and I know, it's happened elsewhere, is that there have been fewer claims.
Yes, and I think because of the time lag that's historically existed between an incident occurring and the claim emerging, that's been something which has been difficult historically to capture. But by us being closer to the incident, I think in maternity brain injury in particular, we will now start to measure those incidents in real time, and hopefully that will accelerate our ability to evaluate the impact of what we're doing.
You and I have talked about this so many times, and I know it's not the purpose of today, but that's always been my concern about the need to intimately link the investigation to the family and the clinical team and to NHS Resolution to get the learning back, and then rather hopefully we'd see what's happened in Sweden, which is after maybe a lag of a year or two, that the number of damaged babies will begin to fall. So are we setting up such a system for measurement like that, of using each baby counts or whatever?
Yes, we are collecting data on those incidents which now have to be reported to us in real time. And we're also triangulating that data with the Each Baby Counts reports and the reports to the neonatal database as well, to make sure that the information is complete and accurate.
Can I, sorry.
Well, only to go on to say that to extend that now to what we're currently doing here today, I know that you've had a number of claims in relation to mesh, and maybe valproate as well. I mean, how has the learning from those claims been fed back immediately to the trust of the individuals concerned?
I think in relation to the trust, those claims are very visible to them because of the information that's shared back with them by way of the scorecards, so they will see in real time, as we do, the claims that they're getting through.
But you give an account for each one, because there haven't been that many, as to why you decided that the claim needed to be settled.
John, would you like to?
Where a claim needs to be settled, we do seek the Trust's agreement to an admission of liability, and that will necessitate usually obtaining independent expert evidence. So if our expert criticises the actions or inactions of the Trust, we will send a copy of that report to the Trust and say, this is our independent view, what do you think? And the Trust will have an opportunity to comment on that report. If they accept the conclusions, then fine, and those conclusions will constitute learning for the Trust in relation to...
And what about the individual clinicians?
We don't have any direct control over that. because our dealings are usually with the Trust's claims department or legal department. We can ask that these reports are fed back, and usually that does happen because people in the Trust's legal department are not clinically qualified usually, and therefore they need...
Wouldn't it be good to be sure that it happens?
It would be good, I agree. But I can't think of an obvious way of us insisting upon it.
Can I just ask, because thinking about the claimants, the people who feel they've been wronged, I understand it takes you about 14 months, the median time to resolve those. And it's now 40% longer than they were a decade ago. So I'm just wondering why it all takes so much longer now to settle a claim.
Yes, we looked at this because, as you know, the National Audit Office made some recommendations on the cost of clinical negligence and some of the drivers that lay behind that, and they observed a lengthening time to settlement. Part of that is attributable to the time it takes for us to hear about the incident following its occurrence, and that might be because the claim has taken some time to come through, or it might be because the claimant lawyer has wanted to investigate it before reporting it to us. And then there's a part of the time is from the claim coming to us and that claim being resolved. And what we've seen is that there's a number of factors driving that. One has been the volumes of claims coming through. Another has been, we've noted that sometimes when cases get into litigation, formal litigation, that can slow down the progress of the claim. We also saw from our data that an extending time to resolution was more a feature of those claims which we resolved without a payment of damages than it was for those with. So it's taking us longer to, I suppose, explain to the injured patient where there was not an entitlement to compensation and then close the claim down than it was on those cases where compensation was due to be paid. So there's a number of features driving that which we've been analysing and which we've recently reported back to the Public Accounts Committee onto.
Right, so what are your plans for speeding up then?
So we've focused on the brain damage baby cases because those have the longest period of time to resolving them, sometimes many years. And our focus there has been getting sight of them sooner so that we don't have that incident to claim lack. In relation to other cases, we've been discussing with the Ministry of Justice how we might speed up the court system. And we've also been focusing our efforts on keeping things out of formal litigation, because if that's where claims slow down, then it's clearly one way of tackling that is to stop them going into court proceedings in the first place. So we've been trying to increase the number of cases which are resolved without court proceedings being required. We've also increased the level of mediation, which we found to be a very effective way of not only bringing matters to a head sooner, but also giving the patient a voice in the process, an opportunity to sit down with the trust, with the clinicians involved, and for issues to be explored in more of a neutral, safe space than is possible with court proceedings.
What's the update on the mediation?
It's increased hugely, actually, particularly in the last 18 months, 2 years. We set ourselves a target of 50 for the first year of giving this a real push, and we trebled that in the first year. We set ourselves a target of 80 for this year, and we've already more than doubled that. So I think as lawyers get more used to mediation as a process and more practiced in it, and can see the benefits of it for their clients and for patients and for healthcare staff too, it's getting more traction. So certainly something that we see has benefit that we're keen to press on with.
Yes, and it's particularly effective in those cases where there's something at stake more than money. So it might be that the trust hasn't apologised. It might be that the patient has particular concerns about something that the trust is doing or is not doing. Those issues can be addressed in a mediation with a trust representative present, whereas in the normal mechanism for settling a claim, all we can do is offer money. But a mediation can offer a much broader range of remedies.
I think some of the advice you give to women, we've heard this through the mesh sufferers, is that they ought to be suing their surgeons. Now, has that advice come from you? Because certainly the women find they can't do that. They don't want to do that. They have been deeply disabled, hurt, in real trauma because of the mesh case. But I just sort of think, you talked about mediation, and I just wonder what percentage of cases you can resolve through mediation, because that seems to me a better solution than actually suing your surgeon.
Yes, I would agree, and I think that in relation to your first point, the advice that's been given to women, that wouldn't have come from us, because NHS trusts are vicariously liable for the actions of all of their staff, and we pick that up through our indemnity schemes, through the trust membership.
Sorry, if I could add, what we do if a claimant is contemplating litigation and we can't get anywhere on the claim, we always advise claimants and their lawyers to sue the trust. We never advise people who are involved with an NHS body to sue an individual clinician. It doesn't happen for the reason that Helen's given. So I think that advice might have come in the context of private treatment, where an individual surgeon probably is not the employee of a private healthcare company.
Right.
But then a lot of activity on NHS patients takes place in the private sector.
It does, but most of that we cover under our indemnity scheme as well, including the liability of an individual clinician.
So why wouldn't you contact the private hospital?
We would in that situation, yes. No, what I was addressing was the chair's comment that somebody has advised patients to sue surgeons. That has not come from us.
But if you had concerns, I know how your indemnity scheme works with the NHS hospital trusts, but how does it work with a private hospital? I mean, if you had concerns about the quality of care in a private hospital, how do you deal with that?
Sorry? Yeah. Our clinical negligence scheme for trusts covers certain private hospitals. It's voluntary, so the company may or may not choose to join. Covers those hospitals for their NHS contracts. So it covers both the organisation and the individual clinicians who are undertaking the NHS work at the private hospital.
So if it's an NHS patient in a private hospital that is part of your scheme, your conversation will not be with the surgeon, it will be with the hospital.
It will be with the hospital initially, yes, but it might be with the surgeon additionally.
So why wouldn't it be additionally with the surgeon in the NHS hospital?
There's no difference, it's exactly the same. We will always go through the relevant legal department or claims department initially, and it might be necessary following that to have direct dealings with the surgeon, but normally we try to do it through the legal department as a smooth process, rather than contacting thousands of different doctors.
So if a surgeon has implanted mesh, might they have received financial support from mesh manufacturers if there is a case brought? Do you know any of that? I mean, we just wonder if there's some conflicts of interest that we would really want to know about, or patients would want to know about.
That's not a feature that we picked up in the claims. I don't know if John has any better information on that. It's not something that's crossed our radar.
That you would ask?
I suppose in relation to, or we would ask for disclosure of all relevant information in relation to the management of the claim. We want to see absolutely everything that might have relevance, and indeed that will be disclosable to the patient as well, and their lawyer will be entitled to, in full transparency, to investigate. As I said, it's not something we've come across, but if it's a line of inquiry that was raised with us, we would certainly pursue it with the organisation.
Right, thank you.
Can I just ask, there are some products, and sodium valproate would be an example here, that can give rise to both a product liability claim against the manufacturer and a clinical negligence claim against the NHS. And as we've been talking to people as we've gone around the country, people who have taken sodium valproate and are claimants have talked to us about their feeling that they get kind of passed from pillar to post between NHS Resolution and what you do on the one hand, and the manufacturer trying to, each of you trying to abdicate responsibility, as it were, that's how they would describe it, to each other. So it's kind of being passed from pillar to post, and no one actually resolves the claim. Would you, that's their perspective, do you agree with that perspective?
John, do you want to talk about the...
No, I don't agree with that, because if there has been negligence by one of our members, then we will pay the claim. We might want to pursue a further claim against the manufacturers. We might not. But if there has been negligence, then we will deal with that claim on behalf of our member. However, if the claim is a product liability claim, then there is strict liability in law on strict liability on the manufacturers under the Consumer Protection Act. So that claim is properly against the manufacturer because the trust has not made product usually.
I think the problem in the case of valproate is that the argument would be that doctors didn't know what they should have worn because they weren't made aware of at the right moment in time. And that's one defence that the claimant would be confronted with, and on the other hand, the manufacturer would be saying, well, we did everything we needed to do. We put warnings on labels and on boxes and so on. So it wasn't us. So the claimant is left in a sort of no man's land between the two.
Yes, I mean, I can understand why some claimants think that because of what happened in relation to the sodium valproate group litigation almost 20 years ago. We can't speak for the manufacturers, but as we said in our paper, we actually gave disclosure of our QC's advice in the context of transferring that claim from the NHS to the manufacturers, which we thought would be a more sustainable avenue for compensation for the claimants.
I suppose from a simplistic point of view, which I'll take for the purpose of this conversation, that if you're involved in a motor accident and there's a dispute about who's at fault in that motor accident, assuming you've got the appropriate cover, you as the driver of as one of the affected parties will get a payout. You may get your car replaced, and the insurers will sort it out between themselves behind the scenes later. So the claimant gets an appropriate form of redress, compensation or payout or whatever you want to call it, and the two insurers can sort it out separately. Is there not some equivalent way of looking at things in relation to the point I'm making about product and medical negligence?
There's always room for negotiation and discussion with other defendants, of course, and we do that regularly where, for example, the medical defence organisations are co-defendants. So that's always an avenue. But in relation to the sodium valproate claims, our defence, in our view at the time, was pretty clear, which was a defence based on the Boden principle, namely that it was considered at the time that sodium valproate was the best drug for many of those patients.
Thank you.
Right.
Yes, can I ask you about the indemnity scheme for GPs that you've been asked to set up, where you are with it and what that's going to look like? Is it going to mirror, for example, the negligence scheme for trusts?
It's slightly different because we will be covering, it's a system level of coverage rather than membership level. So for example, for CNST, NHS trusts are members of our scheme and they pay a contribution to us, which is based on a pricing methodology, which is weighted on experience and exposure. But for CNS GP, as it's now called, that will be centrally funded, and general practice, because it goes further than just the individual GPs, will be covered under that sort of umbrella coverage from the 1st of April of this coming year. The regulations have just been laid for that scheme, and we have been asked to be both the administrators and the operators of it in relation to incidents occurring after the 1st of April date.
Is that going to cause you problems, being both the administrator and the operator in that sense?
No, it's analogous to the other indemnity schemes where we are both administrator and operator.
I mean, and what is your concern? Obviously, the NAO reported on the sort of affordability of the other scheme, the trust scheme. How is this going to be different? How are you going to be in a place that's considerably better than looking at the CNST?
So I think that probably goes to the broader issue of the costs of clinical negligence, which on the basis that the calculation of damages settlements is the same, whether it's negligence in general practice or it's negligence in secondary care, then that is a broader issue for government. And what the NAO highlighted was that it's not just an NHS trust issue. In fact, it's not even just an NHS Resolution issue. It is a broader government issue, not least because the compensation framework is managed by the Ministry of Justice rather than the Health Service. So that whole issue of the cost of clinical negligence to the system
Is that payout rather than the cost of running the scheme or needing the scheme?
Yes, the cost of damages and the legal costs which are attached to the recovering those damages as
Are
well.
outside your remit in that sense?
They are to a degree within our control, but the legal framework which governs the basis on which we make the payments is set by the Ministry of Justice.
Helen, can I ask you a more general question? It seems to me the function of NHS Resolution is twofold. I mean, you may not agree with this proposition, but it is firstly to help the system reduce the amount of damage that patients incur as they go through treatment. And secondly, maybe it's not in that order, to make sure that the taxpayer gets the best value they can for what is a state-funded system. So that you're balancing those two things. But the way you operate is determined within a set of rules established by Parliament. How would you like those to be changed to help you do your job better?
I think our aim is to get to the right answer as quickly as we can within the legal framework that we operate within.
So I'm asking whether you think, in this day and age, because your legal framework is quite old, whether there's some things you'd like to see changed with that legal framework. I mean, one or two things from my recent connection with this area seems to me I wouldn't mind seeing changed.
I think two things come to mind. One is the way in which legal costs are dealt with. And the Department of Health has run a consultation on fixed legal costs for claimant law firms. That's currently work which is with the Civil Justice Council, which we're contributing towards. We found that fixing legal costs has been effective in relation to the management of the defence cost side. Certainly our own lawyers have been working to fix fees for many years. So it's the legal cost side, I think, which is already under consideration by the Civil Justice Council at the request of the Department of Health. I think the second aspect is the once and for all settlement of damages, which is problematic, particularly in relation to the most serious injuries, where someone has lifelong care needs. And essentially what...
Is this the 1948 personal injuries we're talking about also?
Lump sum versus...
This is lump sum versus an annual payment for the rest of that individual's life. So at the moment, we have to make an assessment based on a point in time and the expert evidence that we have to hand on how somebody's care needs might unfold, sometimes decades into the future. And that's very difficult for both sides, because for the claimant, clearly they want to ensure that that person will be cared for the rest of their life. And for the defendant, we want to make sure that provision is adequate, that it's right, that it's appropriate, but not that it's excessive, bearing in mind that the cost ultimately falls to the taxpayer. So that once and for all snapshot is problematic. That's one of the reasons that we've been accelerating the liability investigation and looking to make interim payments on the brain injury cases at a much earlier stage. So responding to needs when they occur, rather than trying to make a once and for all multi-million pound settlement at a point in time.
But also, if you're looking at lump sums versus periodic payments, presumably the changes in the discount rate, relatively recent ones, will have a larger impact if you're depending on which way you go. So,
that's exactly right. We've for a long time been able to pay those high value settlements by way of periodical payments for life, but they are in themselves fixed at a moment in time, so it would be £100,000 for life, irrespective of anything which might befall that individual during their lifetime. So then their care needs might be worse than expected or actually less than expected, and the payment doesn't adjust to reflect that. But we do have that advantage of being able to compensate in that way. Coming to Dr. McLeod's point, there is the issue of the discount rate and the way in which that affects the value of lump sum settlements in particular. So where we have a high value claim, where we don't have the option of making annual payments, the value of that will very much be affected by the court discount rate, which is set at that moment in time. And of course there's legislation which has just gone through Parliament to address that issue.
Yes, so you say it addresses the issue. So do we now have structured payments? I thought there was something called structured payments, which actually is something that you can assess the needs of somebody, that it doesn't depend on a lump sum, but you can review their state, whether they need more care or less care. Doesn't that exist?
We do, as I've said, make structured payments. So we call them periodical payments.
But sorry, does the structured payment then have to come from the lump sum, or can you change the lump sum?
No, we make a lump. When we make a payment for those very high value claims, we'll make a lump sum payment up front for immediate needs like accommodation and adapting accommodation and aids and equipment and so on. And then we will make an annual payment for the duration of that person's life. The difficulty is that payment is not reviewable in the event that their care needs are less or more than expected.
And if I could add, periodical payments and structured settlements are the same thing.
Okay, I think we'll draw this session to a close. I want to thank you very, very much for coming. And if there are any questions that you want to ask of us that we haven't covered, or any information you think we should have, we would really welcome that. But I'll just check with my team. Any more?
One
Yes,
last.
one more. Yeah.
Just one. Well, one maybe. It was really to do with the duty of candour and the implementation of the duty of candour, and whether you have seen any impact of that, and whether you, in your claims, do you ask if there's been a duty of candour disclosure, and has it impacted on claims rates or anything like that?
It's something we've done some research on recently as well. We commissioned the Behavioural Insights team to look at the sorts of factors which led people to
Your paper, yes.
Yes, bring a claim following an incident or a complaint.
Mm-hmm.
And clearly one of those was, as we thought, when the patient hasn't had an appropriate explanation, when they've not been involved in the investigation and so on. So that validated what we've long said, which is that candour is absolutely critical when something goes wrong, that transparency and honesty is more likely to prevent than cause a claim. I've brought this with me, which I'll leave with you. It's our Saying Sorry leaflet, which is widely distributed in the NHS, which makes that absolutely clear. In terms of how it's going, I think that its experience is variable. We've certainly seen some examples of some fantastic practice in the service, but also examples of where things could be improved. But it's certainly something that is a key focus of our work with our member trusts to ensure that patients do get an explanation as soon as possible.
And on that sort of theme, in terms of sort of moving down the pathway to earlier in the claims process, I've noticed that you've got a memorandum of understanding with PHSO, and sort of how do they interact? How does that work in practice?
So we are working very closely with PHSO to make sure that we give the same messages to our NHS Trust contacts, because essentially we're dealing with the same claims and legal teams, and it's important that we say the same things to them, particularly on an important issue like this where we're absolutely aligned. So the purpose of that recent publication was to make that fundamentally clear, but also to explain, I suppose, how our two organisations interact and where there's areas of overlap, how that will be managed.
Yeah. So I mean, from a patient perspective, as a patient on that journey, do you think it's now clear where you need to go?
I think that guidance was aimed particularly at the trust legal teams because they'd asked for it. This is the leaflet we use, which is both patient and organisation facing. I think that in terms of patients being aware of their rights to a full explanation, their right to candour, I suppose it depends. That in some trusts there's a lot of direct support for patients in navigating the process, and in some perhaps it could be better. But it does need to be, it's a very clearly an oft repeated message through a variety of means.
Well, we've got no more questions at the moment, and I wondered if you had any questions for us.
I don't have any, but more than happy to provide any information following today's hearing, if that would be of assistance to the panel.
Thank you very much. John, all right. Can I thank you so much for coming?